Welcome to the Whistleblower Newsroom. I'm Christina Borgeson. In less than 2 weeks, on May 16th, 2022, the trial of former Hillary Clinton campaign lawyer Michael Sussman will begin. Sussman's indictment for misrepresenting himself to the FBI as a concerned citizen instead of the Clinton campaign's lawyer while delivering false allegations connecting Trump to a Russian bank is the second to arise from special counsel John Durham's investigation into possible government misconduct during the 2016 elections and the origins of the Justice Department's Trump-Russia probe. Meanwhile, former President Trump has filed a racketeering lawsuit in Florida against top-level Clinton campaign and DNC officials, saying they conspired to, quote, cripple his bid for the presidency by fabricating a scandal that would be used to trigger an unfounded federal investigation and ignite a media frenzy, close quote. A conspiracy that Trump charges cost him tens of millions of dollars in legal defense fees. If allowed discovery, this case, coupled with Durham's probe, could bring the Clinton campaign Russiagate operation, its key players, and what they did into very sharp focus. My guest today is working on a more sensitive angle of alleged Russian interference in the 2016 elections and hasn't been doing it longer than Mr. Durham has been on his job. Although the official narrative is that the Russians hacked DNC servers to provide WikiLeaks with damning information on Hillary Clinton and her campaign, among other things, Texas lawyer Ty Clevenger has, through freedom of information fights in the courts with the FBI, CIA, and NSA, exposed a multi-agency cover-up of evidence showing that no Russian hack of the DNC took place and that DNC staffer Seth Rich's death is most likely connected to WikiLeaks having received the DNC data from an insider. A significant part of that cover-up involves various fraudulent activities in which the Foia offices of these federal law enforcement and intelligence agencies engage to avoid releasing documents that the public has a right to see. Clevenger is here today to detail this malfeasance, talk about what he's uncovered lately, and explain why, even though John Durham and his team should be very interested in what he has uncovered, they are pointedly ignoring him. Welcome, Ty.
Good morning.
Michael Sussman's trial is going to begin on May 16th, and he was the Clinton campaign lawyer who went to the FBI and fraudulently presented himself as a regular citizen, bringing this information about Russian collusion with Trump, when he was actually part of this whole operation funded by the Clinton campaign to promote the idea that Trump was colluding with the Russians, fraudulently promote that idea. You have been pursuing the whole Russian DNC hack. So here we have, on one side, we've got the Russians hacked the DNC and what was behind all that, and that's what you've been pursuing. And then we have the Durham who's pursuing how did all this Russian collusion stuff come about? And at some point, it seems to me that these two inquiries should intersect.
Yeah, they should have already.
Why should they? And why haven't they?
The reason they should intersect is because, as you know, I'm working on the Seth Rich Foia, and the FBI has been forced to turn over hundreds of pages of records that it originally said didn't exist. So the FBI started out saying that, let me back up. Of course, the idea that Seth Rich was the source of the DNC leaks was just mocked. And anybody who talked about that was treated as a conspiracy theorist. In fact, there's a Rolling Stone reporter, Andy Kroll, who's writing a book and appears to be in that direction, that the whole thing is just a conspiracy theory.
Now, Seth Rich, just to remind the audience, he was murdered in 2016.
Right.
Shot from behind.
Right.
He was a DNC staffer. And apparently he was walking home and he got shot. And Washington, D.C. police said, well, this is a robbery gone wrong, when there was actually no evidence of that. Later on, a lot of things were coming out that connected, and this is what your efforts have been about, that connected Seth Rich's murder with the conveying of DNC emails and stuff from the DNC server to WikiLeaks.
Right. One of the
Okay.
interesting things we discovered is that there were FBI field offices in San Francisco and Las Vegas that were out interviewing people. They've taken possession of his work laptop, at least the data from his personal laptop. There's another computer disk, there's a video disk. And again, the FBI was originally claiming it had no records about Seth Rich. So clearly they were very involved in this. There's the email from Peter Strzok, the infamous FBI agent, who at one point says that he squashed the blank, and it doesn't say what. And so we're fighting to get the redactions pulled off of this. But anyway, there's very clear evidence now. There's something going on with the FBI. It was involved in the investigation. FBI would not be involved in the street robbery, obviously. So we've been reporting a lot of this to Durham and his people, and no response whatsoever.
I was looking at lawflog.com, which is your website that reports on your efforts. And I was just looking at the headlines from June 2020 to mid last year, 2021. And, here, June 2020, new Foia lawsuit seeks FBI records about Seth Rich. December 2020, FBI changes story, finally admits it has thousands of pages of documents about Seth Rich. December 30th, National Security Agency hiding communications between Seth Rich and Julian Assange. January 14th, 2021, CIA refuses to say whether it framed Russia for leaked DNC emails. FBI apparently ignored Seth Rich's laptop. April 23, 2021, FBI releases records about murdered DNC employee Seth Rich. And then the last one is CIA calls Kash Patel. He's the Trump administrative official who said CIA was sitting on damning information about Russian collusion. So it's CIA calls Kash Patel a liar. So clearly, you have sussed out some very damning evidence showing that there is a connection between the government and a cover-up of Seth Rich's murder. This is why. It
begs the question, why? Why would they do that?
Exactly. I really want to get into the details of your court fights with these various government agencies, because they're absolutely fascinating, and they themselves are a study in how a cover-up is run, at least in the FOIA realm. But let's talk about the convergence.
And I'll throw this in, just something tangential, but I've argued for years that we need criminal penalties for FOIA violations. A lot of the states have that if you violate their open records laws. The feds, there are no consequences whatsoever, and they know it. And they just don't care. They don't even try to comply.
It's very interesting that you say that, because other people, other lawyers are noticing in other major cases of government malfeasance that a lot of the federal laws cover malfeasance against the government, but do not address government malfeasance against others.
Right.
And this is a whole area of the law that needs to be developed.
Yeah, absolutely.
So that being said, we started our conversation by talking about the convergence of your efforts and Durham's efforts. So could you talk a little bit about, first of all, what Durham has been up to and what he did and what you've been up to, and how they should converge and why they're not converging?
I should start off with mentioning a website that I follow. It's called theconservativetreehouse.com. There's a guy that writes on there by the nom de guerre of Sundance, and he has been arguing for at least a year, actually definitely longer than a year, that Bill Barr was the Bondo to cover the wreck, and then Durham is the paint to cover up the Bondo.
What is Bondo? I'm sorry.
Bondo is what you use to fix a hole in a car.
Oh, okay.
Okay. Like bullet holes or whatever.
Oh,
So,
okay.
I
Bill
feel that-
Barr.
yeah, and I didn't believe him at first, but now I totally believe that. The most important argument he makes is that Durham is only going to go after private defendants. So he's going after Sussman, who's a lawyer, doesn't work for the government. He will eventually, I'm certain, go after some of these tech people who helped put the whole scam together. He's probably going to go after people at the DNC. What he's not going to do is go after somebody like John Brennan. He's not going to go after somebody like Jim Comey, the CIA director, FBI director, respectively. He's not going to go after the people inside the government who were involved in this. And the reason I say that, or at least that's the belief I'm coming to, is because we have begged him to look into this evidence that we have. They won't even talk to us, just ignore us.
Wow.
So I have low expectations.
Why is it that you feel that former U.S. Attorney General William Barr is the one who's holding this cover up together?
When he was the AG, he was basically almost like controlled opposition. He would go after certain things. He denounced Russian collusion to an extent, but he never carried the football across the goal line.
So basically what you're saying is Durham is running a containment exercise
Yes,
in his investigation.
I believe so.
That correlates with a Wall Street Journal article recently. I think it was the May 3rd article where they're saying, oh, this trial is coming up. And it looks like, I'm paraphrasing here, okay, what Durham is going after is he's basically going to show that this is a dirty tricks thing on the part of the Clinton presidential campaign. And, you know, these people, they lie about their opponents. And it's not good, but there's nothing really criminal about it. And so it's going to be a nothing, move along, nothing much to see here. This is a Wall Street Journal sort of setting up. It seems like they're setting up what's going to happen. But the Wall Street Journal says they've done a great public service in exposing these shenanigans. So there's no mention of any criminal liability for Hillary Clinton here.
Right. And I don't think they'll ever go after her. No matter, if there's a smoking gun in her hand, I don't think they're going to go after her. There's just a level of people in DC who are truly above the law. And so you may get this bit player, Michael Sussman, you may get the bit player at the FBI.
This is what I don't understand. If Michael Sussman is there representing the Hillary Clinton campaign, who's in charge of that? Hillary Clinton, she needs to be brought in because she's the whole, she's in charge of all this. She's the capo di tutti capi who okayed this thing.
I think the biggest obstacle is Merrick Garland is the Attorney General, and it doesn't matter, like I said, if she's got a smoking gun in her hand, it's just, they're not going to go there. She's probably going to run in 2024. They don't want to cause any more damage than necessary to her or the campaign. I mean, people at that level, just, they don't get touched. Now on the civil side, I think that's a different animal. I think, Trump's lawsuit down in Florida where he's got racketeering allegations, I think he may get some traction on that.
Could you talk more about that?
Trump, I don't know, a month ago, maybe longer, filed this racketeering suit in Florida that is alleging, and he named Hillary Clinton in this one, that there was a racketeering enterprise that was created to cause him. He lost money because of it, and that a lot of these people are involved. There are a whole lot of players named in this. And so I think more easily than on the criminal side, he's going to be able to get documents out of the DNC, and regardless of whether Durham or Barr are willing to go there, I think a private litigant can get that stuff. And incidentally, that parallels with what we're doing with the Foia cases. We're forcing this stuff out of the hands of the FBI. Nobody may ever be held criminally responsible, but I think the public will know just how dirty the FBI is.
I just don't understand why nobody can be held criminally responsible. How can that be?
Political interference. Washington, D.C. is.
So our laws mean nothing. They do not apply to these agencies.
No, just to the little guys. I mean, I've said for years, Washington, D.C. is the world's biggest mutual blackmail society. Everybody's got dirt on somebody else. And so, once you get to a certain level, you're untouchable, but you don't rat out anybody else. I think that's exactly what's going on.
So Trump's lawsuit, his civil lawsuit in Florida, is that all about the Russian collusion story and how he lost money? What else did he say he lost? Do you know?
Well, on a racketeering suit, you can't, at least in most interpretations, you can't allege just injury to your reputation. It has to be to your business or your property. So it's a little harder to prove. But as long as he can pass that hurdle, and I don't care if it's $1 worth of damage to finances or business or whatever, then you can keep the racketeering lawsuit alive. And of course, the purpose of this lawsuit is not to make money. He doesn't need it. The purpose is to get discovery, to be able to conduct depositions, to ultimately have videotape depositions of people like Hillary Clinton, and then to release that to the public. So I kind of like what we're doing with the Foia cases.
Have you been in touch with those lawyers?
I have. I've shared information with them. I don't know what they're going to do with it. Hopefully they will pursue the Seth Rich angle as well. I think there are a lot of people sitting around waiting to see what we get out of the Huddleston case, which is the case trying to get the Seth Rich records. Let's
start talking about the Huddleston case, because a lot has occurred in the courts and a lot of things have been done and said that I think the public should hear about. Now, it was in 2017, right, that you filed a FOIA seeking information regarding misappropriation of DNC emails and Seth Rich, right?
Right.
Start there. And now Huddleston, explain who Brian Huddleston is and talk about the filing and talk about the response to that filing, the FBI's response.
Right. So originally, 2017, I filed a FOIA in my own name. The FBI didn't respond, so I sued them here where I live in Brooklyn in federal court. First of all, the FBI comes back and says, we don't have any records. We've searched our index systems and we don't have any records. And Judicial Watch, in a separate case, had requested the text messages of Peter Strzok and Lisa Page, the two infamous lovebirds at the FBI who were deeply involved in the Russia collusion story.
And what text messages were they looking for?
All of them back and forth, just to see what they were up to with all this Russia collusion stuff. So just by happenstance, there was a text message exchange back and forth between them about Seth Rich. There were some other people involved in the text message exchange. And then at some point in there, Peter Strzok says he squashed this with blank. We don't know who that was or exactly what that means, whether it was a reporter or somebody else. So that just came up during the course of the 2017 case. Separately, the federal prosecutor assigned to the murder in DC conducted an interview where she made all these disclosures about the government's involvement in talking to the FBI. And so,
wait a minute, assigned to the what?
So the case was assigned to the U.S. Attorney's Office in D.C., so I should give a little context there.
Yeah.
It's a very unique jurisdiction. They don't have a district attorney who prosecutes D.C. crimes, whether murder, robbery, that kind of stuff. It's actually it's a federal district. It's the U.S. attorney that prosecutes the local equivalent to state level crimes. So, she was the one that first let it slip that she had relayed information to the FBI. So,
is that Deborah Sines? Is that the homicide?
Yes. Prosecutor. Okay. She's retired now.
Okay.
So I put that out in front of the court here in Brooklyn where I live, and the judge just shrugged it off, threw the case out, without allowing any further discovery or forcing the FBI to do a better search. Just threw it out. And so I had this friend in Collin County, Texas, which is north of Dallas. And there's a judge there who, ironically, was appointed by Obama, but is very much a straight shooter on this kind of stuff. And so we filed it there.
Is that Judge Mazant?
Judge Mazant.
Okay.
And he's not a partisan. He just calls, balls and strikes. So he has been very fair to us. And the FBI now has been forced to admit that it had hundreds of pages of documents. Many of these documents were not in its index system, which.
So when they initially replied, they were disingenuous because they basically said, we don't have anything in our index system. So they limited that. The cover up there is they limited it to in our index system. Is that
Let me talk about that index system, because we're now getting into something that's much more far-reaching than just this one Freedom of Information Act case. What we're discovering is that, well, we already knew this, that whether something gets added to the index system is entirely left up to the agents working on the case. So it's very subjective, very subjective. One of the questions we had is whether and who might have given orders to don't enter this into the index system. But we know there's a lot of information, whether it's intentional or accidental, and I think it's probably intentional, that gets left out of the index system.
So that's the first opportunity for a cover-up act. Absolutely. For a FOIA is, you know, that this is a hot potato, you know that there's some stuff behind this, do not enter it into the index system.
Well, what we're also discovering is that there are entire databases, there are entire divisions within the FBI that they just don't search, that are not part of this index system. And so that's the scam, is in all these FOIA cases. If you're not experienced at dealing with the FBI, that's the way they dupe you. They come back and say, oh, we searched our index system and there's nothing there. And like this first judge in Brooklyn, most of these judges, rubber stamp it, and that's the end of it.
Right. So what happened there in Texas?
What we gradually sussed out was that, there's a lot of documents that were not in the system. There's thousands of pages originally. Now they're saying hundreds. We're going to fight over that. We want to see the full original set of documents. Out of all the documents they produced, they have completely withheld, or documents they have identified, they have completely withheld 85%. The remaining 15% are heavily redacted, which begs the question, why? If this is a street robbery, as they have maintained, first of all, as we just talked about earlier, why is the FBI involved? Well, they're not for a street robbery. And then why are they redacting all this? I
need to understand something, because you said Washington is considered a federal district. So right. Who should be involved in it then?
Homicides in the district are investigated by the Metropolitan Police Department.
Oh, okay.
DC local police department. And that's who is, has claimed that it's investigating the murder.
Are they still investigating it?
That's what they say. But, again, begs the question, if they're the ones investigating the murder, the FBI is claiming we're not investigating the murder, well, then what else would you be investigating besides the leak of the DNC emails? So, that takes us back to Durham. Why isn't Durham involved in this? Why isn't he getting the documents that we're getting? Why isn't he trying to get documents from us? And so far, no interest. I mean, it's possible that the grand jury, Durham's grand jury, is issuing grand jury subpoenas and getting some of this, but I see no indication of that.
It might be an interesting exercise to send him some very, very salient documents.
We're going to do better. Whatever we get, we're going to, spread it to the media, put it up on the website so anybody can see it. And I'll email him and his investigators again, but in the early stages, one of my clients, Ed Butowski, did talk with one of the investigators and tell him, look, there's all this stuff. Talked with him by phone, called him. Ed reached out, not the FBI agent, and relayed this. Said, look, there's all this stuff here. They never responded. I mean, I've got the business address of John Durham himself. I've got the business address. I've got the email, the official email for him, for his chief investigator. We've emailed him multiple times.
Let's go back to you on behalf of Huddleston filed this complaint in the Texas courts. And that was in 2017. And some other things happened in 2017, like in May 2017, former technical advisor for the NSA, right, Bill Binney, along with 12 other retired intelligence professionals, published this report explaining that the DNC emails were extracted and transferred so quickly. that they couldn't have been obtained by an external hack.
Somebody stuck a thumb drive in and got it. That's the only way it could have
Somebody
been.
inside the DNC, because they had to have access to those files.
Which is where Seth Rich worked. Seth Rich worked for the DNC.
Exactly.
He's got access.
Another important thing we need to talk about is December 2017. Sean Henry, the CEO of CrowdStrike, which was the company hired by the DNC and relied upon by FBI and Director Mueller to examine the DNC computers, testified. Was it before the House Intelligence Committee, I believe?
I believe it was.
That his company had no concrete evidence that the DNC were hacked remotely. So the DNC hired this CrowdStrike, and eventually they report, after a lot of press reports implying that, oh yeah, they found that this was a hack. And then all of a sudden they walked it back in the testimony and said, oh no, we have no, and then the House Intelligence Committee, now this is in December 2017, and the House in May 2020, so they wait a few years, they publish Sean Henry's testimony. October 2020, journalist Cy Hirsch testifies that a source inside the government told him that the FBI had examined Seth Rich's laptop and that Seth Rich had requested payment from WikiLeaks. That was a bombshell. I read that. I thought, oh, I didn't realize he had asked WikiLeaks for payment.
And all the media ignored it. Most of the media, except for a handful of conservative sites. Even Fox News is ignoring stuff like that. I should say something really interesting about this. To my knowledge, never in the history of the FBI or Federal Department of Justice have they allowed a victim of a computer crime to hire its own private company to do the initial investigation and then turn it over to the FBI without the FBI ever even looking at the computers or the hardware or all this stuff that supposedly was hacked. I mean, that alone stinks to high heaven.
Was all this before the FBI said to you they had nothing on Seth Rich? They had no.
Right.
God, that's such a colossal lie.
Yeah, and when we haven't talked about the CIA, I mean, the CIA is, I filed this FOIA request on the CIA because I got a tip that said ask whether the CIA fabricated DC leaks and Lucifer 2.0. And I should back up and explain that. Or I'm sorry, not fabricated. But when the CIA was running that, and I'll explain what those are. And then also Cozy Bear and Fuzzy Bear. Well,
right.
Cozy Bear and Fuzzy Bear are inserted into all these DNC emails, and so and attributed to the Russians. And so my question is,
it's supposed to be the fingerprint proving that the Russians, this was a Russian operation. Yeah.
And so I asked the CIA, specifically that you found. Well, first of all, generally, did you insert fingerprints into these emails to make it look like the Russians did it? Did you fabricate Cozy Bear and Fuzzy Bear? And were you running DC leaks and Lucifer 2.0? And they came back and said, we can neither confirm nor deny.
That's what they call a Glomar response, right? Yeah.
And I talked with a former CIA agent who said, if they could have denied that, they would have come out of the gates and said, we would never do such a thing. And instead they're saying, oh, it's a national security issue. We can't talk about it. So we're litigating that right now in federal court. Why would you deny something like that?
Yeah, exactly.
Answer.
Right. So, wow, that's a kind of a high sign, isn't it?
It is.
A Glomar response is something that if you really didn't do it, you would want to deny it.
Right, exactly. And there are exceptions to classification on national security grounds, one of which is that whether the CIA was involved in illegal activity. And so if they did this, then it was illegal. And so they don't have any basis for asserting classification. So that's what we're arguing in court right now.
One thing I think is very important to discuss, because this is one of the most overt examples of illegal CIA activity, is the CIA by law, it's not allowed to operate in this country.
And it is, it clearly is.
Let's talk about the CIA operating domestically in this case.
Let's start with one of the most egregious examples, and this was some time ago, but the CIA hacked into the Senate Intelligence Committee when Dianne Feinstein was the chair of that committee. I mean, think about that for a minute. It's a separation of powers issue. You've got Congress, which is supposed to be exercising oversight to the CIA, and the CIA hacks into the Senate Intelligence Committee, and nobody gets prosecuted for that.
Why did they want to do that at that point? Was there?
We still don't know, because there was never any real investigation. There was never any explanation. But the most plausible explanation is, they didn't want they wanted to know what Senate intelligence was looking at. And somebody should have gone to prison for that, whoever was involved, and nobody did. So, we know they're doing dirty stuff like that. Cheryl Atkinson, who was a CBS reporter, had somebody hacking into her computers at work, at home.
She'd wake up in the middle of the night and hear her computer turning on.
Right.
And actually, she also said at one point she was actually watching as her computer was remotely hacked. Okay,
somebody went to her house as a Verizon repairman in a Verizon truck and apparently installed a bunch of spyware in the house.
There's no limit anymore. But yeah. I want to get back to, I remember Bill Binney from the NSA, ex-NSA, right, technical director, saying the whole Russian collusion thing was a CIA-directed operation. And he was talking about Brennan and Clapper from the CIA, ex-CIA. And that's interesting because that would connect the Hillary Clinton campaign, their Russia collusion operation, to, former CIA people.
Absolutely. And I should mention that Brennan who was the CIA director, is a rabid partisan. I mean, a complete politico for the Democratic Party. And so, and he's connected with, like you said, with all this initiation of Russian collusion, and, had FBI agents working on a task force with his people. So that's somebody that Durham should be hauling in front of a grand jury. Somebody should be prosecuted in all likelihood. Not going to happen.
Now, what about Comey? Talk about talk about what he did to promote this whole thing and cover it up.
FBI director, who later got fired by Trump, was neck deep in this stuff. I mean, he's involved in the documents and some of the email exchanges. He helped create Russian collusion. So, yeah, he needs to be hauled in before a grand jury. It probably won't be.
Well, again, that's somebody else that Durham should be dragging into his, grand jury investigation, right?
Well, my hope is that through the Huddleston cases and some of these Transparency Project Foia cases, lawsuits, I should say, we'll get enough documents that's going to force somebody's hand. I mean, you can't directly force somebody's hand, but if we can get enough smoking guns, then hopefully some congressional committees will show some interest and haul some people in to testify. And maybe eventually, if there's a change in administrations, then somebody will get prosecuted for it.
Has anybody from Congress shown any interest in your information?
Not yet, and I'll tell you why. And I've described the Seth Rich story as the last bus stop before Pizzagate. Nobody wants to touch this story because then you'll be labeled a conspiracy theorist or a kook or whatever. And so nobody in journalism wants to touch Judicial Watch, which
yes, I noticed they're sort of limiting their hangout there.
Went out and said, "Oh, we're going to go after records on Seth Rich," apparently saying that as a fundraiser. And they never did. They've done nothing on this story. And so they're leaving it to us, some ragtag bunch of people to do it for them.
Well, that's always the case, right? I mean,
right.
You're the Transparency Project, by the way, is your own nonprofit looking into all this.
Right.
I want to move on to FBI's FOIA malfeasance in the Huddleston filings and in their responses to the filings. And the first thing I want to do is talk about the different types of activities, and then you plug it into how they did that in their answers to your submissions. The indexing we already talked about. Then the limiting of their searches. Okay, they don't search all databases or relevant databases.
Right.
They don't, and there's no way for you to know, really.
Exactly. Well, that's what I'm hoping Judge Mazant will really give us the leeway to plow into is what databases are you omitting from this search? So everybody else who's doing a FOIA request will know, we have to ask for this database and that database and this database, not just their indexing system.
Right.
To find out what's going on. And I tell you another one, I did not mention this. They are fighting me tooth and nail not to search emails, not to search their text messages. And I told the court the absolute least we should be able to get the emails and the texts of these agents in Las Vegas and San Francisco and DC who are out interviewing witnesses and taking custody of evidence. We should be able to look at their emails or have their email searched to see if there's any reference to Seth Rich or Aaron Rich, which is his brother. And the only thing the FBI came back with was it was not reasonable, and they didn't elaborate.
In your filings, you call that not being conclusory. In other words, if you are going to make an argument, you have to back your argument up with the law that shows that your argument is valid. And it's true. It's absolutely striking how the onus is on you to do that, obviously, right. And you do it in your filings, and in their filings, they just say, well, no, it's not reasonable. No, we don't have to do it. No,
most courts just say, okay, fine, rubber stamp, throw you out. And,
yeah, so you have to keep coming back, and you have to keep citing the law on where, in fact, you do have the right to ask for these things.
Actually, that's what you have to do is figure out where the courts are going to be friendly, just like the state attorney generals do. There may be 15 attorney generals who want to file a suit over immigration, and what they do is find the court where the judge is going to give them what they want. Both sides do that, left and right.
Right.
And sadly, we've reached a point in our history where you have to find the right judge.
So the other thing that they do is they lie about having responsive documents, right? And that is, of course, proven by first they tell you they have none, and then all of a sudden they have thousands. Right. Yeah. And I noticed in one of their responses to them saying that they don't have to give you all these documents is that, oh yes, you said that they withheld all these documents, but that's not reason enough to say that they acted in bad faith.
Yeah, we cheated across the board, but that's not bad faith.
These guys, I don't, it feels like they're smoking crack. I'm just a joke, but what's interesting to me is do they just rely on the judge not really paying attention to the details of their response or something?
I think that's part of it, but I think there's a big bias in favor of the government. I mean, think about it. Who do judges work for? They're creatures of government themselves, and so right. They want to say, "Oh, the government acts in good faith," and that there's, if you read the case law, there's this huge presumption of good faith.
It's so interesting because the U.S. Constitution itself says, "Hey, we have this Constitution because, you can't trust the government. You can't trust it. And so here are the fundamental rights of the people as everybody is sovereign, and this is and so it's so interesting that all of a sudden we have this system where these judges who are supposed to, the fundamental legal document of all legal documents in the United States of America is that Constitution.
You're reminding me of something, change the direction here a little bit. Most FOIA requesters file their cases in Washington, D.C., including Judicial Watch. That's why we moved the Transparency Project to Texas. That's the last place I would file any FOIA
That's so request. Interesting. Yeah, that's a very important information for anybody who wants to have an organization like yours looking into government malfeasance.
Absolutely.
Go to a state that is fair.
Right. More importantly, find the judicial district in that state where you got one or two judges. They're going to play fair. That's where you headquarter your organization. Or if you're an individual, you have the option of filing a lawsuit whether you live or in Washington D.C. Never file it in Washington D.C.
Right.
It's just that I've referred to the federal courthouse in D.C. as the most corrupt federal courthouse in America. And I could go into all kinds of detail about that, but yeah, you got to get it out of D.C.
And I don't think New York is a very good place.
It's
either.
absolutely not. I learned that the hard way.
Let's keep going on with the FBI's malfeasance. One thing they've done to you too is ignored your requests altogether. They ignore the requests, and it takes time for you to respond and force them, so we're watching you age as you're trying to get this thing to, so that's another thing, the foot dragging, the line that allows them to drag their feet.
That is the norm across most federal agencies. You're not going to get anything out of most federal agencies on a FOIA request unless you sue them.
And that's part of the making it a long, terrible process for you as a way to discourage you. And, that should be somehow illegal.
It is, but there's no teeth, there's no, it's not enforced. And, there's the Office of Special Counsel in DC, which, not to be confused
useless.
with Robert Mueller,
I know them.
Completely useless. That's their job to prosecute FOIA violators. I did a FOIA on the Office of Special Counsel, and they had to come back and admit they have no record of ever prosecuting a single government employee for a FOIA violation, ever. I mean, and there's no criminal penalties. I mean, at most, the person can get fired. But in the history of that office, it has never happened.
God. Oh, and our tax dollars are just paying for these useless, corrupt individuals. It's so annoying. It's worse than annoying. It's an affront. Next malfeasance point. They improperly redact documents. Could you talk about that in this case?
I'll give you a very clear example of that. So there's an FBI 302 form, which is the forms that the FBI puts together when they interview somebody. And let me back up a second on that and talk about 302 forms in general. So in the Huddleston case, the Seth Rich case, we have asked for the 302 forms, of course, for the interviews, but not only that, the initial handwritten 302 forms, and then the drafts of the 302 forms. And the reason that's important is because we know from the Michael Flynn case that an agent can take handwritten notes in the field, but in the process, it gets edited, and you might have something completely, significantly different in the final 302 forms. So that's exactly what we've asked for in the Huddleston case. They are fighting us tooth and nail to give over these handwritten notes. The other thing, and how crazy this is, if you're a street cop, in some podunk town, in Mississippi, you're going to have a body camera on you. And anytime you interview anybody, it's going to be videotaped. And 20 years ago, when I was a cop, if you're going to interview a witness in a witness room, it's videotaped. You look at all these TV shows on, crime channels, everybody's videotaped. FBI does not do that.
That's crazy. Right. They never have a precise and accurate record of their interviews. And I think that's deliberate.
Absolutely.
That's a big, and to me, that's another one of those, this is a way that allows you to cover up. Yes. And that should be changed. That should be changed.
Congress should absolutely adopt legislation saying you have to videotape it. You can't do this handwritten stuff. It's ridiculous, especially in this day and age.
Yeah.
So anyway, we're fighting to get these 302 forms. But anyway, so the reason we know that they're making improper redactions is because one of these 302 forms, they redacted out the name of Deborah Sines. They redacted out the name of Aaron Rich. And I knew from looking at the form, based on the public statements that Deborah Sines has made in interviews and in her deposition, because I deposed her.
Again, she's the former
prosecutor assigned to the Seth Rich case.
The homicide. Case. Yep.
And it's, based on what is in that 302, they interviewed her and they talked about her and they talked about Aaron. They redacted her name out. They redacted Aaron Rich's name out. So they're just willy-nilly, redacting out whatever they want to. And so it's not just the fact that they're improperly withholding documents altogether, they're making these redactions. This is not new to my case or to my experience. I mean, this has been going on for decades now. It's well established in multiple cases. And so my argument to the court in Texas has been this idea of a presumption of good faith needs to be completely rejected, not just in my case, but across the board with respect to the FBI. And if we can get a judge in Texas to make that ruling, I think that's going to have a watershed event where other FOIA requesters can take that opinion and say, no, the FBI doesn't get the benefit of a good faith assumption.
Let's talk about how they improperly withheld documents.
The NSA, they have not disclosed anything related to Seth Rich, given me Glomar responses, cited the statute, which is unique to the NSA, that says any information that they collect is not subject to FOIA. However, the exception to that is information that they receive from other agencies. So, for example, if the FBI or the CIA taps into an NSA database and gets information, then my argument has been, that's no longer NSA information. Another agency has it. And certainly any information that the CIA or the FBI gets and gives to the NSA is not subject to a FOIA exemption. So we're fighting that out right now. But, in fact, in one case, for example, I requested information on the 16,000 people that the FBI illegally surveilled. And there's a court opinion out of DC on that. So I asked for the names. And NSA originally refused. And then they came back and said, okay, we agree. And I think the only reason they did that, they haven't produced it yet, but I think the only reason they did that was because it was the FBI that did this, not the NSA. In fact, the FBI tapped the NSA database to get all this information.
Okay, but can they also say, well, it's the FBI's information, go get it from them?
They can, and I've asked for the FBI, from the FBI as well, but that doesn't mean that they're not also supposed to produce it. FOIA applies to them even if they got it from another source and they didn't originate it. So that's why we ask for FBI and NSA.
Invoking national security exemptions when they shouldn't. That's like a rock and a hard place situation, because if they're invoking national security, you can't see whether or not they're doing it to hide a crime. And the one major exemption for invoking national security concerns is hiding a crime, hiding criminal behavior.
Absolutely. Yeah, that's an exception to the Glomar, or not the national security classification. So we've pushed that hard. Sometimes if you make a request, like, for example, when we asked for evidence about whether the CIA inserted Russian fingerprints, that's clear. If they did that, that's clearly illegal. So they don't have a leg to stand on. But if you make a broader request and you don't know, or your request is not couched so that you can say what I'm asking for would show illegal activity unquestionably, then it's a lot harder to get that stuff because you don't know what they're holding back or what they're redacting. So you can ask the judge to hold what's called an in-camera review, where he reviews it in chambers. And I suspect we're going to be doing that in several of these cases. So
you have to know about the crimes that they have committed and are covering up with a national security response to be able to fight their national security response.
Right. And so that's why, for example, one of our requests is for the CIA's surveillance on U.S. journalists. For example, Cheryl Atkinson. We've asked for her specifically. We asked for journalists in general. But that request is couched so that if you did it, it's illegal. It's, the CIA is prohibited from doing that domestically. It's a due process, privacy violation. So yeah,
they're just going to say, well, we don't have that, and just lie about it. They've
done
it
very well. Yeah, that's the other biggie. These guys can just lie about whether they have it, and then there's really not much you can do about it at all. And that's why I think there needs to be criminal penalties for government officials that do that.
Who's going to start crafting these laws and getting them passed? Getting them accepted and included as part of the legal system.
That's a great question. We need somebody in Congress to really step up.
That person would be a real lightning rod for some attack, I'll tell you. Because at this point, there is such a huge body of criminal activity at the highest levels of government that nobody wants to see that.
Well, like I said, DC is the world's largest mutual blackmail society. So, my concern would be if somebody steps up to do this, then the CIA is going to try to find, tap their computers, tap their phones, try to find some way to intimidate the person. I mean, they did it to Feinstein. They did it to the Senate Intelligence Committee, and they got away with it.
I mean, it's all unspeakable. So talk about the evidence showing that the FBI deliberately concealed Seth Rich's role in leaking emails to WikiLeaks and supported the Russian collusion fraud.
Well, so one of the things that the FBI did, or one of the more recent arguments, is they said, well, the only thing that Clevenger can prove is that we originally said we have no documents, but he can't prove that that was untrue at the time. Well, it's totally false. I mean, they had his computer, they had 302 forms. I mean, they had lots of evidence that's relevant.
Do you think the judge is going to see that?
Absolutely. I mean, it's as plain as day.
And what about their support of the Russian collusion?
That right now is not as clear because they've really not turned over much of anything. This is the one where the FBI has proposed that there's over 1 million documents. And even in the first round, I think there were 500,000. So the FBI, over 500,000, the FBI wanted to produce it 500 pages per month. So even with that initial number of 600,000, it was going to take 83 years for them to produce this stuff. And now they're coming back saying, no, it's 1.5 million. So, we're talking 150, 200 years to produce all this stuff. So that's something we're fighting out in court right now.
How else could they release them in a way that you could get them in a reasonable amount of time?
The judge would have to just order them to do it and say, bring in whatever resources you need, hire contractors, but get it done or else.
I've read with great interest the FBI's response to the various aspects of because they want a summary judgment against you, basically, right, against Huddleston. They want the court to decide right away, yes or no, is he allowed to have these documents or not? And of course, you don't want that, right?
Definitely not. Yeah.
And you have actually filed what's called a cross motion, right?
Yeah, cross motion for summary judgment. That's pretty typical.
And so you're basically saying you want summary judgment, we want summary judgment.
Right. So cross motion for summary judgment is us saying, these guys didn't produce anything. They need to be ordered to produce all of it. I don't think we're going to get our cross motion. And actually, in a sense, we don't want it. We want discovery. We want to be able to take people's depositions. We want to get to the bottom of some of this stuff.
Right. And with summary judgment, you will not have discovery and you will not be able to depose witnesses. And so you will never get the full story unless you're able to do that.
Right.
They keep using the word conspiracy. You're presenting conspiracies and conjecture in your filings to the court, which is why they don't have to respond to anything that you are asking for.
It's a straight out of the CIA playbook. You discredit people by accusing them of creating conspiracy theories. Well, it's no longer a conspiracy. I mean, I caught them red-handed. They denied they had the documents, and then I proved that they did. So that's not a conspiracy theory.
Yeah, and their response, amazingly enough, is just, oh, well, okay, yes, that happened, but, that's not enough to show bad faith.
Yeah, exactly.
And that's
ignore that man behind the curtain.
Yeah, they said that Huddleston has woven a tale of conspiracy and conjecture to establish that the FBI acted in bad faith in conducting searches. And then the reason why they say that you have not proven your case for getting these documents is that you have engaged in conjecture regarding the circumstances of the malfeasance because you have used newspaper articles. Well, not just that, but you have used newspaper articles and used press accounts to back up your request. And that the press and newspaper accounts are not verifiable sources.
That's true in a general motion for summary judgment, but Foia is unique because all you're trying to prove is that there's reason to believe that the records are there and you're not just making things up. And so for that reason, in FOIA cases, most courts have said you can refer to newspaper articles to establish things, or not establish things as fact, but to establish that there's reason to ask for the documents and get more documents.
If you have a plethora of reports that are saying the same thing over and over and over, I mean, these are outlets that don't necessarily talk to each other or communicate with each other. So
Right.
They are disparate sources and they are all saying the same thing. So, and all you're saying is, so this is worthy of your consideration for validating our request, that they give us these documents.
Exactly.
The other thing they're contending is that you have no right to any documents about Seth Rich, because even though he's dead and dead people have no rights, and so you should be able to have access to them, now they're saying you cannot have them because of his survivors. They have a right to privacy.
And there is some argument to make there, but and I made this point in court, I'm not asking for his Facebook messages about his girlfriend or the movies that he's watching. I've asked him specifically to search those computers for relevant information, and they're just refusing and saying, oh, well, it's covered by the right to privacy. Well, no, it's not. I mean, if he was doing this, and another point I made was his brother is one of the ones that's fighting that, as well as his parents. His brother, has gone into public interviews, said he had played no role in it whatsoever. He's filed a lawsuit against my clients saying that he had no role in leaking these emails. He no longer has any privacy interest. If these documents, whether it's a 302 form or messages on the computer, he has no privacy interest in that.
We were talking about how Seth asked WikiLeaks for payment. Could you specifically talk about the source of that and what the source said?
That came, and it's not firsthand, but it came secondhand from Assange, Julian Assange.
What did he say?
According to my source, he indicated that the way they did it was eBay and PayPal, and it's a really easy way to do things. You put a candle for sale on eBay, and somebody buys it for $50,000 or whatever, and then you PayPal the money to that person. So that's not hard to do at all.
So is this a confidential source?
Yes.
Do you think the FBI would have tracked that or has information about that?
If it happened, it's almost a certainty that they would have that.
And you've requested information on that?
Well, we've requested everything they have on Seth Rich. So, who knows what, I mentioned that 10-page document that they want the court to review in camera. And one of their arguments is that if it's revealed, and it will give away some of their investigative methods. Well, that would not be phone records then, because we know they use phone records. It would not be bank records, because we know they get bank records. So what would that be? Would that be records they got from PayPal, records they got from direct messages from Twitter? We don't know.
Wouldn't that be things like how we wiretap people's phones or how we go in and put bugs in people's? Is it more along that?
They're claiming these 10 pages came from a commercial institution, whatever that might mean. So it's pretty broad.
Why would the commercial enterprise have to be protected?
Well, it's a great question. If, for example, if it's PayPal or if it's Twitter and they're just voluntarily giving this stuff up without a warrant, well, then, that's something they don't want to be public.
Do they have a legal right to keep it private?
Well, there is a provision, there's an exemption that says proprietary and confidential information from a private company may be subject to protection, but that's not an absolute.
But that's not proprietary information.
Exactly. That's our argument. It's not the same, unless it's a patent or the formula for Coke, then there's no privacy interest. Then they would fall back on, well, it reveals our investigative methods. And that's where things get interesting. Well, what are you talking about?
Given what Durham is looking into, what information do you have that he can use? And what information does he have that you could use that would converge your two cases?
So I don't know exactly what he has. He has no obligation to disclose it, and he plays it very close to the vest. So, I don't know what he's sitting on. I just know right now all he's focused on is the Alpha Bank stuff. And so he seems
Talk
to
about
be-
the Alpha Bank. Explain to the audience.
There was this wild claim that the Russians had a direct link to Trump, and it was related to this bank. And now we're finding out the whole thing was completely bogus. It was completely made up. So Durham is going after that. And that's when Michael Sussman, the lawyer, took this stuff to the FBI, lied about who he was representing. So that's the big focus right now. The question is whether Durham is truly trying to get to the source of the DNC leak, not just the broader or separate compartmentalized aspects of Russian collusion, but is he really trying to find out where the leak came from, whether it was Russians, whether it was somebody inside the DC or something like that. Right now, there's no public indication that he is. So the information that I have about Seth Rich, could be very relevant to what the true source of the leak was. But he's not talked to anybody in our group. He's not talking with anybody like Bill Benny or any of these guys who have the technical expertise. Theoretical, he's got independent people who could do all that technical analysis, but we've not seen any evidence that he's going that direction.
I want to talk about what the CIA, how the CIA responded. Basically, they said it can't be compelled to provide records about the DNC because if it were to confirm the existence of responsive records, that confirmation would show that the agency devoted resources to this effort.
And we already know they did. I mean, John Brennan convened a working group on this stuff. It's ridiculous.
Yeah, but
we know they did. It is a completely bogus argument. There is no national security interest whatsoever in showing the fact that you devoted resources.
But isn't that
to it.
proof alone? Isn't it proof alone that there is public evidence that they were involved in this, that they have broken the law by engaging in domestic operations?
Well, begs the question, if this is illegal and you didn't do it, then why wouldn't you just come out and say, we didn't do it, it's illegal and we didn't do it? It's outside our charter, it would be, privacy violation. Why wouldn't you just come out and say that instead of saying, we can't comment?
In the court, can they be forced to say whether or not they were involved?
Absolutely, and I'm optimistic that they will.
In as much detail as you can, explain what's going on with Durham and why what he's doing should be converging with you. When you hear about his mandate, you hear them say Durham's mandate is to look into the origins of the Russian collusion story. And right now, the Russian collusion story is limited only to not the DNC leaks. It's to the Steele dossier and all that.
It's linked to looking at these actors who tried to blame everything on Trump, these private actors who tried to blame everything on Trump. There's no indication that Durham is looking into the government people who were involved in this.
If he's not looking at the government people involved in this, is that how he carves out the Seth Rich murder?
Yes. If that's what he's going to do, again, I don't know exactly what he's doing. Maybe he's going to prove me completely wrong, and I hope he does. But so far, there doesn't seem to be any interest in truly finding out who was responsible.
Is there any indication on his side that there's any contemplation at all about the DNC leaks and the Seth Rich murder being part of the Russiagate, the entire Russiagate landscape?
Nothing public. Certainly if it's going on, he's kept that private because there's nothing on the public record to indicate it. They're looking at that. Now
he's got Sussman, and he's going after the Russian who allegedly
helped with the Steele dossier. It was the source of some of this information.
So he's still focused on the Steele dossier. Who would he go after next? Who's the next logical? Because, if you're doing the little fish, you eat the little fish on up to the big fish. Who are the next big fish that he would go after to get to the bottom of that side of the Russiagate or Russian collusion story?
Well, the next level, or at least at some point, pretty near that, would be going after the DNC, going after the people who were behind this, whether it's Robbie Mook, who was Hillary's campaign manager, or whomever inside the DNC.
Debbie Wasserman?
Perhaps, or going the next step beyond that, Hillary herself. I just don't think he's going to go that far.
All the people who were named in Trump's RICO suit?
Yes, I think that's why if we find out anything, it's going to be from Trump's lawsuit.
So interesting, because it's almost like there's a space between these two efforts, between your effort and Durham's effort, and it seems like Trump's lawsuit is dropping in between that in terms of the information being sought.
He's in a better position than anybody else to just tear the whole thing apart. I mean, he can go after either side of this, the source of the DNC leaks, the whole Alpha Bank, the Fusion GPS. I mean, he's got the standing now just to get all of it.
Well, I think we're going to leave it at that, and we're going to see what happens. I thank you for coming on. This is an ongoing story that I'm happy to pursue to the bitter end, because I think your work is extremely important, because through this case, you are exposing with a glaring spotlight all the holes in our legal system and the missing laws that we really need to start putting on the books so that we can get back to having a true democracy and a justice system that works. Thank you.
Thank you very much.